I want to start today just by expressing condolences to Sam's family and friends who have been forever impacted by his passing. Although I never had the opportunity to meet Sam, it's as if I've known him his entire life as this case has progressed over the last year and a half. I've had the opportunity to hear from his educators who described the love and patience they had with Sam, spending time with him on the playground, teaching him basic skills, and spending time without him outdoors. Other friends of Sam talked about the joy they received from taking Sam on hikes or going into water with him in a highly supervised setting. They described the love that they gave him and that the love that they received back from his presence. Although Sam was had a normal 16-year-old body, he had severe autism. The cognitive ability of a 2 to 3-year-old was nonverbal, not toilet trained. Sam also had a history of significant self-harm to himself and harm to objects around him. Despite this, Sam experienced love and joy and had a very bright future ahead of him based on those educators and friends that were part of his life. What's so heartbreaking about defendant's conduct is this was not a one-time incident where Sam was left unattended. And to try and cast this as a one-time incident is not accurate. It's troubling to me that the defendant took responsibility fairly candidly, it seemed like, at the time of the plea, but then seems to minimize his actions as part of PSI and kind of his version that he recites. Let me be clear, Sam was in no way able to care for himself, yet he was routinely left unattended. There were 15 occasions law enforcement or CPS was summoned to the home, primarily because Sam was unattended and had escaped from the residence. Sometimes he'd be found in nearby streams, sometimes he'd be found several blocks away, many times he'd jump the fence kind of in the backyard of the house. But this was a regular occurrence where CPS and law enforcement was going to the home. Sam's death was not an unexpected result. Each time Sam was left alone, it was like playing Russian roulette. Tragic, but not an unexpected result in this matter. The consequence of defendant's actions resulting in the loss of a child's life could not be more severe, and the consequences should be a strong factor taken into consideration by the court as part of its sentence here today. Likewise, I just want to touch on the culture of this family, the way that Sam was treated in this family, criminal, sad, and cruel. Sam's bedroom that he had resided in for years was unfinished, had a bare mattress, exposed plumbing, feces smeared on the walls. It was not an appropriate environment for the child. Likewise, it was hours after Sam was left unattended that Mr. Koets had directed his youngest daughter to check on Sam. And I know that the PSI, the texts are relayed in there, and I just want to touch on a couple of those because I think they really shed light on this circumstance. So recall, Sam is left unattended at 1 to 1:15 in the afternoon. Roughly 4:07, Mr. Koets sends a text to his youngest daughter saying, "Okay, are you home yet?" She replies back, "Just walked in." The next comment from Mr. Koets is, "Okay, would you make sure Freak is okay?" He follows it up with, "Is mom still asleep?" So is Freak okay? Is mom still asleep? The youngest child then replies back, "Sure, where is he?" And Mr. Koets said, "He's supposed to be out back." So this is not the assertion that the child is supposed to be watched and inside is just not supported by the facts of this case and the text record in this case. Mr. Koets goes on to say, "Or else in his room maybe, if mom put him there." Then it's at that point Now at 4:11 in that afternoon, remember he's been out there since between 1 and 1:15, that a photo of the child is sent, a text is sent of the child in the pool with the water up to his waist in the pool. That is texted directly to Mr. Koets at that time. And what is his response? His response is, and these are his words in the text, tell him to get out of there, go get and pull him by the hand, and then he will come. This young child says he's in the middle. The response is, yell at him and tell him to come here. The child then says, I think he's stuck. Several more minutes goes by, and the father says, okay. Another photo of the child, Sam, is shown in the water, with the water up to his waist. And that photo is sent, and then the father responds, pull his testicles out. And how is any of this an appropriate response to this autistic young man being in the water, thrusting this on the child to deal with this situation, when it was Mr. Koets' actions that led to the child being placed outside? The sequence of events is important here. It was Mr. Koets' decision to place this child outside. This was a culture of lack of respect for Sam and putting Sam in harm's way. And this text chain, as indicated in the PSI, gives further insights into how Sam was treated by Mr. Koets. The story, unfortunately, does not end there, as is documented in the case that ends in 631FH. For 8 months after Sam's death, Mr. Koets continued to fill Sam's prescriptions. And what he would do is, because the doctor's office did not know that Sam had passed away, these were not like auto refill prescriptions. They'd have to call the doctor's office, get the prescriptions refilled, then they would be sent over to the pharmacy, then you would go over to the pharmacy and have to pick them up. And this continued on for 8 months after Sam's death. Some of those prescriptions, 3 of them in fact, were submitted to Blue Cross Blue Shield for insurance payout. And as a result, there's $110.85 that is due in restitution back to Blue Cross Blue Shield for the money they paid out on those 3 prescriptions that were filled. But this was a pattern of conduct that happened over 8 months after his death. Nothing we do here today can bring Sam back. And I think that's important. And I think a lot of people that look at this case, you know, they have very mixed emotions and kind of the sentencing range in this case, and I can understand why. But nothing we can do today can bring Sam back. But it's important that we fashion a consequence today that's appropriate to Mr. Koets' conduct, and also sends a signal to the community that this behavior of some of our most vulnerable citizens is not acceptable, is not to be tolerated. Especially children that have disabilities deserve dignity, respect, and appropriate care at all times. I believe a prison sentence is appropriate in this case. Would ask the court to sentence in that 19 to 38 month minimum range on this matter as a result of Mr. Koets' conduct. Thank you.
I also think that we do need to make some adjustments on the plea agreement that was agreed. I'm on page 1 of CFJ 284 under evaluation and plan. It's the last sentence under docket 43611. It's my understanding that the court goes above or under the guidelines that the defense or the prosecutor may withdraw the plea. Is that accurate?
That's fair, Your Honor.
In the same last sentence under the first paragraph of 43631, which is the next paragraph. So what we need to do is put a slash after the above and put under and insert under. and a
Yeah.
slash after defense and put prosecutor.
That's agreeable.
No objection.
And then the last sentence on 43631 I've just struck. There we go. All right, Mr. Coleman.
Yes, thank you, Your Honor. May it please the court, Dave Coleman, appearing on behalf of Mr. Koets. We agree with the scoring. I'm not sure I actually said that on the record. We agree with the scoring changes that were made, Your Honor, and have no objection. Your Honor, I can go through the usual. My client has his lack of prior record, his family, his work history, his wife's work, and all those sorts of things. But this is a very unique and tragic case. My client is very sorry for what has occurred here and has to live with this for the rest of his life in these circumstances. The court needs to know that, and I think it's clear, Sam had never gone into the pool like this before. That's when we talk about the first time, or my client talks about that. That's what he's referencing. He's never denied that Sam had issues and would run and hop the fence or do things and they would have to find him and all that sort of thing. He had never gone in the pool before. The pool was covered. Your Honor, this is not, I'm not blaming anybody here in terms of my client's actions. But Sam was a very high need child. He required 24/7 round the clock supervision and care. He was in the room that was in the house because of the way he destroyed everything else in other rooms, literally tearing walls out and beds apart and all these sorts of things. And my client and his wife had consistently and repeatedly sought help from community services, CMH, other organizations, and that's documented. And there's just nothing there. I'm not trying to blame that. It's not an excuse. But I think it provides the full context here, Judge, that this is something, understand, this is a child for 16 years, that they had to deal with these behaviors 24/7. Constantly cleaning up after him, constantly repairing what he was doing. My client that day was there, had to go back to teach at school. His wife was home. He woke her up. That's clear. He did that. And then he left. Did he make a mistake by not making sure she was upstairs and there? Absolutely. But he did go in and wake her up, thinking as he was leaving that she was up. He has to live with this the rest of his life. His family has to live with this. I spoke to his daughter, Shaylee. She wanted to address the court, and we're not going to do that, obviously. But she loves her dad. She wants him home. She needs his support during this time, and there's some discussion of her issues also in the report. I just bring all this out, Judge, because I think it's important. I can understand Mr. Krause looking at it from the outside and saying, look what happened here. But look at what happened for 16 years, Judge. My client has to live with that now. And of course, looking back, would he have made sure his wife was up? Would he have done other things? Of course. And actually, I think that one text that Mr. Krause read, where he says, well, check the backyard, but he might be in his room because maybe his mom put him in his room, is indicative of the fact my client thought his wife was up. I just want to mention as a side thing, I don't want the court to have a wrong impression, and I'm sure you don't, but I just want to make sure. There was mention about a book or something that my client was looking at, possibly writing. I don't want the court to think he's made some kind of book deal or he's got money or he's signed it. There's nothing like that. He has simply said he wants to try to help other parents with autistic kids to not make the same mistakes he made. And if he can put that in a blog or online or something out there to maybe help one other family dealing with this same kind of situation that unfortunately our system can't handle and doesn't really provide much help for these families. He wants to do that. So that's the context of it, Judge. I didn't want you thinking he was out there signing with Simon and Schuster or something, you know, or some kind of big deal. There's nothing like that, Judge. I could go on, but I think you see where we're coming from on this. The guideline range is 19 to 38. We asked Your Honor to look at the low end of that guideline range, given all the circumstances and the entire context here. And to go wherever Your Honor feels it's appropriate to go with a sentence like this. But I agree with Mr. Krause. Nothing is going to bring Sam back. And my client is currently the breadwinner in the home, has another child at home, wants to be there for them. It's a fact. I don't know how you balance all that, but that's what we have today. So, Your Honor, we would ask you to use your discretion and sentence my client appropriately today. Thank you.
You're Timothy Koets.
Yes.
Have you had an adequate opportunity to read and review the pre-sentence report?
Yes, sir.
Any additions or corrections that you wish to make?
None that have already been mentioned, sir.
Anything you'd like to say before sentence is imposed?
Yes, sir.
Go ahead.
Well, I'd like to thank Your Honor for the opportunity to speak. It's been nearly 2 years now since March 28, 2019, when my son Sam went to be with the Lord. And I think of him every day. I miss him dearly. And I'm deeply sorry for the mistakes that I made, for the lapses in judgment that I made. I ask forgiveness from God. I'm a believer. I believe in the Lord Jesus Christ. I've asked forgiveness from him, from the court, from my family, and from the community. As an educator, I care about my community, and I feel very ashamed of myself for my conduct. But Sam was with us for 16 years, and during those years, my family and I, Your Honor, we learned how to care for Sam, and we managed his autism the best that we could. And it wasn't easy. We had to forfeit a lot of privileges that many other families have and take for granted. And we did that. We wanted to give Sam a fulfilling life and, give him a good life. And we had ways of coping with his condition. And, I confess, the words that I used were not good. And it was a way of kind of blowing off steam, and I'm not excusing myself for that. But I would never harm or abuse Sam. Would never have done any of that to any of my children. Our home's always been a place filled with love, warmth, and compassion. And I cannot change the past, but I do have the ability to honor my son's memory. And for all the families in our community that are struggling under the grip of autism, I would like to see my role as one who could educate the community, because we've been through this, and we've made mistakes, we've learned a lot of lessons here. And it's families with special needs children are frightened, they're desperate, they don't know where to turn. And I feel like we can minister to their needs. We have an opportunity to provide help because of what my family's been through. And every year it seems like we hear about a child who dies tragically, as our son did. And I'm here, I'm willing, and I'm able, Your Honor, to do whatever I can to help this problem in our community, and to educate people, and to be there and just fellowship with other families. And God has given me another vital responsibility, Your Honor, and that is that He's placed me here to be a loving, faithful husband and father to my children and my wife. And in a day when so many fathers walk away from their families, I'm here, and I want to be with my family. And I want to continue bringing out my girls in the nurture and admonition of the Lord. And my youngest daughter is 15, and she really needs love and care of her father after all she's been through. And So I respectfully ask that the court grant me the ability to continue to support my family financially and physically. We're with them where they are. Our family's been through 2 very difficult years, Your Honor, and we just want to recover, we want to heal, and we want to give back to the many people who have supported us over the past 2 years. So, Your Honor, I thank you for this opportunity to address you. And I just appreciate and respect the prosecutor and for his efforts in keeping our community safe, and I appreciate the work that you do as well. And I just wanted to make this statement, and I appreciate your time. Thank you.
Thank you. The court received a number of supportive letters from your coworkers, church members, friends, family, etc. And I understand that, and it's always good to see. But I want to remind them that you pled guilty, and I'm telling them that Timothy Koets pled guilty to involuntary manslaughter, you pled guilty to child abuse 4th degree, you pled guilty to obtaining controlled substances by fraud. So if there's any thought out there that you are not responsible for the crimes for which you now stand convicted, everybody needs to put that off to the side right now, because you've accepted responsibility for that. Also, in your materials that you gave to me, you are essentially, along with other individuals in the community, asking me to sentence you to some sort of a home arrest or home tether. The plea agreement, which you and your attorney specifically agreed, along with the prosecutors, that there would be a prison sentence. So home confinement is off the table as part of the plea agreement, and everybody needs to understand that that was part of the deal that you negotiated. The court will comply with a plea agreement. The court understands the difficulties of the situation to a certain extent. The court did receive an alternative point of view from the respite providers. They painted Sam differently, and they described some concerns that they had about the house, your house. And in fact, from what they've indicated to me, upon Sam's 18th birthday, they were going to attempt to take over guardianship of him and provide him with long-term care. So there were resources out there in the community that were providing him at least temporary support, and in a couple of years, possibly long-term support. Sam had value. And the sanction will not restore Sam, but it will recognize that all humans have value. And because of the neglect that you committed, a valuable human has lost his life. Therefore, it is the sentence of this court on count 1, the involuntary manslaughter, that you be turned over to the Michigan Department of Corrections for a minimum of 24 months and a maximum of 180 months. You have 2 days credit. On count 4, which is the 1-year misdemeanor, the maximum is 1 year. You shall serve 365 days in incarceration with 2 days credit. You must pay state costs, crime victim costs, and DNA fees that are required by statute. Regarding the companion file, the controlled substance obtaining by fraud, technically the sentence will be above the guidelines, but it is consistent with the plea agreement. Therefore, it is not a deviation from the guidelines because of the agreement. You shall be turned over to the Michigan Department of Corrections for a minimum of 24 months and a maximum of 48 months. You have 0 days credit on that one. You must pay restitution of $110.85. You must pay state costs and crime victim costs. These are final sentences and squarely within the guideline range that everybody negotiated. You may file an application to the Court of Appeals regarding your conviction and sentence. If you are unable to hire an attorney, this court will appoint one to represent you at public expense. You need to fill out the paperwork you've been provided and return it to the court within 42 days. That is all. Thank you.
Your Honor, for the record, my client has already received the appellate review papers, signed them, and we submitted them.
Thank you very much. Thank you.
Thank you, Judge.